Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 3, County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, you have been asked to come to court for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, the felony cases is handled in the district court, whereas the misdemeanor cases are handled in the county court of law. Now, felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious, it just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they're convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to maximum 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type punishments. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start in the JP court or the city court. For example, not having your seatbelt on is a Class C misdemeanor. Speeding is a Class C misdemeanor. Not having an inspection sticker or inspection sticker may be expired. That's a Class C misdemeanor. Now, with the Class C misdemeanors, they come to this court when a person is found guilty in the JP court or the city court and they appeal their case. What an appeal is, they want a new trial. And so if the appeal is granted, they get a whole new trial in this court. Now the range of punishment stays the same, and the range of punishment for a Class C misdemeanor is a fine only. You cannot be given jail time, and the fine cannot exceed or be above $500. Now, however, if you fail to pay the fine, or if the fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capious pro fine. I'll explain that to you. Capious pro fine means that it's a warrant for your arrest to either pay the fine or sit the fine out in jail. Now, if you sit the fine out in jail, every 1 day that you spend in jail, you'll be credited at $100 per day. That will go toward the payment of your fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor, and the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, which is 6 months, or you could be given a fine that does not exceed or be above $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. And with the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. Probation basically means that you serve your punishment out in the community. In essence, you won't go to jail. Okay, now, if you get probation, there are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, and the other type is called adjudicated probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed, and you will be able to get what is called a non-disclosure. Non-disclosure means that your record is sealed to the general public. Now, the operative word is general public. So, for example, let's say you apply to a job at ExxonMobil, and that they're part of the general public, and you have a non-disclosure. They go back and do a criminal background check, you have a non-disclosure, guess what? They won't see the fact that you were placed on deferred adjudication for this case. Why? Because your record is sealed. You got a non-disclosure. However, I said the operative word is general public. Now, the police department, which is part of the government, certain governmental agencies can have access to, but most of the public is general public. They cannot have access. Okay. Now, the next type of probation is called adjudicated probation. We usually call it regular probation. It does result in a conviction on your record. However, there's something that is called judicial clemency. Judicial clemency means that the judge can set your conviction aside and you will no longer have a conviction. It's almost like giving you a pardon. And so you won't have this conviction on your record. However, if you get a subsequent conviction, subsequent means another conviction later on, then the case that you receive judicial clemency on can be brought back up. It can be resurrected or revived, and it can be used against you. And if you try to get a license with Child Protective Services, which is CPS, they can deny giving your license, or if you have a license, they can revoke or suspend your license. Okay, now everyone that's here for arraignment, you should have a clipboard. Who does not have a clipboard? Okay, everyone has a clipboard. Okay. Now I'm going to go over the paperwork that's on that clipboard, okay? And now the first document behind that little tab sheet is titled Judge's Explanation of Rights of Defendants Without Attorney. All right? I'm going to go over that document with you, and I'm going to keep referring back and forth to that document, because everyone that's here for arraignment, you will have to sign and initial that document. You're going to make a choice. All right. Now, that document basically states that as a defendant in a criminal case, before I get started on that, the document looks like this. Okay? This is how the document looks. All right? Now, it states that as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, first one paragraph sentence, well, the first one sentence paragraph states that if you want an attorney and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Reset means you will be given another court date to give you time to hire an attorney to represent you. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, then you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard. Now, this is only for people who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't have to worry about this document or anything that I'm getting ready to say about this document. All right? And if you're applying for a court-appointed attorney, you have to read and fill out the first page of this document, Jefferson County Affidavit of Indigence. And then you'll go to the second page. And at the second page at the top is titled, it says Defender's Oath. You'll fill out the top portion. And then you go to the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. All right. Now let's go back to that first document, judge's explanation. The next paragraph, one sentence paragraph, that is for individuals who will be representing themselves. In essence, you have a right to have an attorney, however, you'll be waiving or giving up your right to have an attorney. Now, if you waive or give your right to have an attorney, you'll have an opportunity to talk to the assistant criminal district attorney here. In essence, just like if you have an attorney representing you, the attorney be able to talk to the assistant criminal district attorney, because you're representing yourself, you are your own lawyer. And so you'll have an opportunity to talk to the prosecutor, and we have one in court today, Ms. Farrah Nixon. You'll have an opportunity to talk to her to see if you can work out a settlement on your case. Now, that one sentence paragraph, that third one sentence paragraph states that you may not speak to the prosecutor unless you first sign a waiver of your right to have an attorney. The waiver of your right to have an attorney is another document that is also on the clipboard. It is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. All right. Now this is only for individuals who will be representing themselves. If you're not representing yourself, you don't have to worry about this. All right. Now, for individuals who will be representing themselves, there's a paragraph. The next paragraph is in block form. That's this paragraph right here that I'm pointing at. And it states that the dangers and disadvantages of self-representation, waiving your right to an attorney and representing yourself, may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, that last paragraph, the last one sentence paragraph on this document, which is right here, this is for individuals who will be representing themselves. It basically says that if you're representing yourself, you may change your mind at any time and ask for an attorney to be appointed to represent you. So, for example, let's say you're representing yourself, and let's say you want to talk to the prosecutor. You have in mind that you would like to get probation, and you talk to the prosecutor. The prosecutor say, "Well, I'm going to offer you jail time, or I'm going to offer a fine." You say, "Well, I don't want that." And you say, "Well, Judge, I changed my mind. I don't want to represent myself. I don't want a lawyer to represent." You can do it. All right. Now, at the bottom of this document, in bold letters, it says defender's choice. Mark initials next to only one choice. Everyone that's here for a case is going to place your initials on one of these 5 lines. You're going to sign and date it today's date. Now, if you would like to hire your own attorney, you'll place your initials on the first line to the left at the bottom. Then you'll sign your name on the line where it says defendant, and you will date it today's date, and then you'll stop. Okay? If you've already hired an attorney to represent you, you'll place your initials on the second line to the left and the name of the attorney on the line to the right. You'll sign at the bottom, date it, and stop. And this is the only form that you'll have to sign. If you'd like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom, sign and date, and then you'll go to this form that is titled Jefferson County Affidavit of Indigence. You'll read and fill out the first page. Go to the second page, fill out the top portion that's titled Defender's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. If you have already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. You'll sign your name on the line and say the defendant, place today's date, and then you'll stop. It's the only form that you would have to sign. Now, if you would like to represent yourself, you'll place your initials on the 5th line, which is the last line here. Sign and date it, and then you'll go to the document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You will read this document, sign and date it, and then you'll stop. Do we have any questions? No questions. All right. Now, before you finish filling that document out, I need to give you some more information. I'm going to talk about some other rights that you have. Another right that you have is a right to have a trial by jury. In that area over there where you see those 12 chairs, we call that the jury box. 6 citizens, because we're in a misdemeanor case, you only have 6 on the jury. 6 citizens from Jefferson County will be selected as jurors in your case. And they will listen to all the evidence that's presented by the state, evidence that's presented by the defense. They will listen to the arguments of the state, listen to the arguments of the defense, and then they will go back into that jury room in the back, and they will deliberate, and they can decide to find you not guilty if you charge or guilty if you charge. You also have a right to waive or give up your right to have a trial by jury. In essence, you have a right not to have a trial by jury. Now, you still can have a trial, but it won't be by jury. It will be a trial by judge. We call that a bench trial. The reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. And so the judge will be the judge and the jury in the case. The judge will listen to the evidence presented by the state, evidence by the defense, the arguments of the state, the arguments of the defense, and then the judge will apply the facts to the law and decide whether to find you not guilty or guilty. Now, you may decide that you do not want to have a trial. Okay? Now, in a case, you can enter one of 3 types of pleas. A plea is, you could enter a plea of guilty. Guilty, if you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of not guilty. If you enter a plea of not guilty, you're saying you did not commit the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you would not be fighting or you would not be contested in charge. Okay? Now, if you enter a plea of guilty or no contest, you can have an opportunity to work out a plea bargain or settlement of your case with the state. If you are able to work out a settlement, let's say you want probation, they offer you probation, then they go before the judge can do one of 2 things. The judge can grant to accept or deny the recommendation that's made by the state, which is the plea agreement. If the judge rejects the plea agreement, then you can tell the judge, well, judge, since you're not accepting my plea agreement that I made with the state, I take my plea back. In essence, I'm not pleading guilty, or I'm not pleading no contest. You have a right to do that. That's what the law says you have a right to do. Now, if the judge does follow the plea bargain agreement, then, and if you decide, say, within 30 days, because I say 30 days because you have a right to file a motion for new trial or an appeal. If you want to file an appeal, you have to get permission from the judge that followed the plea bargain agreement. Now, if the judge gives you permission, your case is going to leave this court. All again, it's going to go to another court. It's going to go to the Ninth Court of Appeals. And guess what? The Ninth Court of Appeals is right above us on the 3rd floor. We're sitting right below the Ninth Court of Appeals. There are 4 judges up there. They can review your case. They can either accept or grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court or to this court to give you a whole new trial. And if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is located in Austin, Texas, and it is the Texas Court of Criminal Appeals. You would have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means self. In essence, I'm representing myself. I don't have a lawyer, I'm representing myself, and I'm petitioning, so I'm asking the Texas Court of Criminal Appeals to review my case to see whether or not my appeal should be granted or whether or not this court wrongfully convicted me or convicted me in error. They can do one of two things. They can grant or deny your petition. If they grant your petition, guess what? They can simply find you not guilty, case over. If they deny your petition, if they grant, they also can send it back to the Ninth Court of Appeals with orders or send it back down here with orders. And if they deny it, then at that point, your conviction will stand. Now, the other right that you have a right to have, we talked about a trial by jury, we talked about a bench trial, we talked about having a right to agree to an agreed plea bargain. The other right that you have a right to have an unagreed plea bargain. What I'll explain that to you. Let's say you're in the state at talk. You're on probation, they offer fine, jail time, and you say, well, I don't want none of that, I still want to plead. You can come before the judge on what is called an unagreed plea bargain, where the judge will decide what your punishment will be. That's called an unagreed plea bargain. All right. Now, you also have a right to have witnesses to come to court to testify for you in your trial. They sit in that chair where the microphone is, we call that the witness stand. Okay, they can testify for you or against you. If you're representing yourself, you can ask some questions. If you have a lawyer representing you, a lawyer can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses. What that means is you have a right not to call any witness. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. You also have what is called a Fifth Amendment right against self-incrimination. I'll explain that to you. Fifth Amendment of the United States Constitution give us the right to remain silent. Zip it, okay? In essence, we don't have to testify against ourselves, to incriminate ourselves. Okay, I know a lot of times we watch television, lawyers, and we see maybe a case like Law and Order. Lawyer go up to the witness stand and ask the witness a question, and the witness say, I take the fifth. That means I'm not saying nothing. Okay? In essence, you have a right to take the fifth or invoke your Fifth Amendment right against self-incrimination. Now, and that just basically means you're not saying anything in your case, you're not testifying. I tell people this all the time, it makes sense for us to have a Fifth Amendment. And the reason why is because it is. The state of Texas, or the government, prosecutors, they have the burden of proof. They have to prove you guilty beyond a reasonable doubt. You don't have to prove yourself guilty. So that's why you have a Fifth Amendment right against self-incrimination. You don't have to incriminate yourself. You don't have to get up there and say, I prove you guilty. You don't have to do that. All right. Now, you also have the right to have what we call discovery. Discovery is you have a right to see what's in the file that the state has against you, okay? State has a file against you. You have a file. They have evidence in there that they can use, that they will use. And so you have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, see photos, listen to audio recordings, right to see documents, instruments, whatever they have. You have a right to have access to that. Okay? Now you can waive or give up the right to have discovery, which means that you say, I don't want to see it, I don't have any access to it. You have a right to waive or give it up as well. Now, the other thing is everyone that's here for a case, charges have been filed on you, you've been arrested, you've been placed in the county jail, you're out on bond, you're either out on a cash bond, which you pay the full amount of the bond to get out of jail, you're out on a surety bond, which means you pay a percentage of the bond to get out of jail to a bondsman, and you may be out of jail on a PR bond or a personal recognizance bond, which means you have to pay no money to get out of jail. They just release you on your own personal recognizance with a promise to appear here today. I've said that to say this. Every day that you spent in jail, it could be used as credit towards your punishment. So, for example, the operative word is day. Okay? Every day that you spend in jail. So, let's say you were booked into jail at 11:59 p.m. last night, one day before, 1 minute before midnight. And let's say you booked out of jail 12:01 a.m., 2 minutes later. Guess what? That's 2 days. Why? Because it's 2 different days. Okay? So Monday and Tuesday. So that's 2 different days. And so you get credit for 2 days. You don't have to be in there 48 hours to get credit for 2 days. All right? It's just the 2 different days. And so let's say you've been in jail 5 days. Talk to the prosecutor, state is offering you 5 days in jail. That means you don't have to spend no more time in jail. Why? Because you'll be given credit for the time that you've already served. So you'll be given credit for time served. And let's say you spend 5 days in jail. Now for and they offer fine and court costs of $500. But every day that you spend in jail, you have $100 credited toward the payment of your fine and court costs. All right. So if you spend 5 days in jail, that's $500, right? That can be used towards your fine and court costs. So if they offer fine and court costs of $500, that means you don't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Okay. Now, if they offer fine and court costs of $700, that means that you have to pay $200 because we subtract 500 from the 700, that leaves 2. You'll be required to pay it on the day that your case is disposed of. If you cannot pay it, no problem. Why? Because we can put you on a payment plan, or you can pay it off in small monthly installments. Now, if you cannot pay it off in small monthly installments, no problem. Because we can convert your fine and court costs to community service. And for every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited towards the payment of your fine and court costs. So, for example, you have to pay a balance of $200. If you work 8 hours one day, that's $100. So you work 2 8-hour days, that's $200. You finish with paying on your fine and court costs. Simple as that. Now, Jefferson County has a program for people who have not been in trouble with the law before. So if you haven't had any convictions before the first time getting in trouble, they have a program that is called pretrial diversion. With pretrial diversion, they will dismiss your case. Okay? Once you get in the program, they'll dismiss the case and you will get it expunged from your record. Expunged means erased, deleted, or wiped off from your record like it never happened. Okay? Now, in order to qualify for this program, one, it has to be your first time getting into trouble. It could be one or more cases. So it have to just be one. It could be, let's say, you went on a crime spree. I don't know. You committed 2 or 3 cases at the same time. You still may qualify. Okay? The other thing is, so it's your first time. The other thing is you have to have an attorney to assist you with the application process. Now, you don't have to necessarily hire an attorney. The attorney could be a court-appointed attorney. All right? And it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. So for all other cases, you can get into the program, complete the program, the case is dismissed, you can get it erased, deleted, or wiped off from your record that we call expunged. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. With the Veterans Court program, all thing you have to do to get in the program is be a veteran. If you complete the program, they dismiss the case. Okay? And you can get a non-disclosure where your record will be sealed. All right? Now, this court, County Court at Law Number 2 of Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office. The program is called the CSI program. CSI stands for Community Safety Initiative. And it is a program designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so how do we address it? We address it through our Community Safety Initiative. And with that program, we have partnerships with various agencies in our community. One of the agencies that we have a partnership with is Spindletop Center. And there's some young people here from Spindletop Center. They'll come in a few minutes and tell you a little bit more about the program. Well, basically, Spindletop is our mental health authority in the Southeast Texas region. Okay, they have the expertise to address mental health issues that a person may have. Now, basically, you don't have to be incompetent or insane to participate in the program. You can merely suffer from anxiety or depression or any other host of mental illnesses. And they have the expertise to address your mental health needs. Now, basically, what Spindletop will do today, they will do a private interview, either in our jury room, at their facility, by telephone or text, whichever is convenient for you. They will also do an assessment to determine what your mental health issue is. And they can develop a treatment plan to address your mental health issue. Now, if you have problems with drugs or alcohol, well, Spindletop has another program. It's a drug recovery program, drug and alcohol recovery program. The program is called ATAR. ATAR is an acronym, ATAR, that stands for Outreach, that stands for Assessment for Alcohol Treatment and Recovery Program. Now, with that program, as I mentioned, it's an alcohol recovery program, and we also have a partnership with our local drug and alcohol council that has a program that's called OZAR. OZAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, Referral. Both of those programs are alcohol and drug recovery programs. And what they will do, they can do a screening, a private screening. They can do an assessment to determine what your alcohol and drug issues are. And then they can develop a treatment plan for either outpatient or inpatient treatment to address your issues that you may have with alcohol or drugs. If you are unemployed, or if you're looking for a better job, well, we have a program that is called, we have a partnership with the Golden Triangle Empowerment Center that has a program, or that has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you're trained in. And if you do not have a high school diploma or a GED, they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time, okay? We take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2 of Jefferson County, Texas, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. If we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, just let us know, and we can direct you to the people that you need to talk to get on the road to living your best life. So at this time, as I mentioned to you earlier, we have Tanya and Deputy DeVille. They're going to come to you and tell you a little bit more about the program that Spindletop has to offer.
That's the question.
Yes.
If a person is on SSI and you come to represent them, like, how does that happen?
What you mean?
Like, I handle all this.
Well, if a person is indigent, they may qualify, and they may qualify for a court-appointed attorney.
No, I'm just saying, like, I handle like all this.
Yeah, but you can't be his attorney because you don't have a law license. Only an attorney can come before,
No,
This
but I
law
can't
and
talk-
actual
I can't
practice.
talk.
yeah, you can assist him and you can assist, and you can help the attorney to assist, but you can't represent him. You understand? Because you're not a lawyer. Only people that can actually practice, before the court of lawyers. But you can help, like, for example, if he has a lawyer and he has an appointment with the lawyer, you can go down with him to that appointment and you could help, help him to, discuss the case with the lawyer.
I was just talking about like if he represented himself.
Okay, if he represents himself, he represents himself.
Yeah,
Nobody else is representing him.
yeah, but I can't be with him.
You're not a lawyer. Yes, he can represent himself, and like on that document, either he has a right to hire an attorney, he has a right to ask for a quote from an attorney, or he can represent himself. He can't represent himself and have you assist him. It doesn't work like that. Now, if he can have a lawyer to assist him, okay? And then at that point, the court, let's say he comes up before the court, okay? And he's representing himself. And then the court realized that something's not quite right. The court has the discretion to appoint a lawyer to represent. Okay? So, when people come before the court to represent themselves, as I mentioned to you earlier on the document, there are dangers and disadvantages of self-representation. Waiving the right to an attorney to represent himself may result in the worst outcome for them. And their case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizen, and employment. In essence, somebody always said there's consequences and repercussions. We call it collateral consequences, not just the punishment, but other things that can happen later on down the line. Okay, that's where somebody with a legal expertise comes in. They help me out with that. Okay. So at this time, we're gonna have the folks who spend the time. You had your hand? Oh, I saw. So I had anybody else have any other questions? Okay, so at this time, we're gonna have folks from spend the time. Deputy Review and Don.
Thank you, Your Honor.
You are.
Hey, Josh Dillon with the Harris County Sheriff's Office with the Warren Division of Mental Health Division. This is my partner where I'm attached to, Spindletop. She's with Spindletop, so we're an essential partner. She's qualified mental health professional. And the pamphlet's a little short, sheet we age questionnaire. It's not mandatory. You want, look at the services that they may provide, that she can on that in more detail.
Good morning, you guys. As Judge Holmes said, I'm Tanya with Spindler Trust. With our services that we have available, if you guys look at the little short notepad, I know you guys probably already watched it, saw it. It gives details as far as we can contact you guys face to face. We can speak with you guys today. We can call, text, even email. With the information, substance abuse, there is also veteran assistance. There is IDD, when we say IDD, that's the intellectual disability. We also have, mental health. Mental top period. We have mental health assistance. With the mental health, we have doctors on site. We have nurses available to give your medication. We have pharmacy on site. Also, we have our counselor and our psychiatrist on site. So you will always have contact with anyone available for your mental health services. As Deputy Paul stated, this is totally optional. You guys don't have to fill this out, but if you would like to speak with us today, just go ahead and note it on here. And once Judge Holmes and Deputy Mosby go through the paperwork, we can speak to you guys. Any questions? Thank you, guys.
Okay. Thank you.
Sir, thank you.
Okay, now, I'm gonna give you a chance to finish filling out the paperwork. And if you need any assistance to fill out the paperwork, we have our court personnel who's here, including myself, who will be happy to help you make sure that the paperwork is filled out properly. Now, Once that paperwork is filled out, once the paperwork is filled out, we're gonna take it up from you. And then we're gonna put you into one of three categories. One, you wanna hire an attorney. And if you wanna hire an attorney, your case will be reset today, which means you'll be given another court date to give you time to hire your attorney. Two, if you would like to request a court-appointed attorney, if you qualify, your attorney will be appointed today before you leave here. And then three, if you would like to represent yourself, that is where you're right, an attorney, represent yourself, you'll have an opportunity to talk to the prosecutor in the case to see if you can work out a settlement on your case. If you are able to work out a settlement, then that case will be disposed of today. Now, it's gonna take a little time for everyone to finish filling out the paperwork and for us to pick that paperwork up from you. And I said that to say this, if you need to use the restrooms, there are two restrooms that's right out in the hallway. There's a men's restroom in front of County Court number 3, and on the opposite side of the hall, there's a women's restroom in front of the 172nd District Court. You'll be allowed to go use the restroom. Please do not leave the courthouse. If you leave the courthouse and your name or your case is called and you do not answer, your bond will be forfeited. A warrant will be issued for your arrest. You will be arrested, placed in the Johnson County Jail, and then apparently you're gonna have to bond out all over again. And guess what? We'll have to go through this all over again. Okay? And so we don't want to do that. We're gonna try to get you in and out of here as soon as possible. Now, and that paperwork at the top, it says the state of Texas versus, there's a line. Please print your name on that line. Because if you write like me, sometimes I can't read my own handwriting. Okay? So just print your name, and if you print your name, we'll know who you are when we call you up. Okay? Just print your name on that. Now, do we have any questions before we go on break? Be mindful that we're still in court. And so conduct yourself accordingly. At this time, the court will be in recess.
Make sure you complete your paperwork before you step out, if not, you're gonna prolong the process.
Jefferson County Court, Order number 2 is back in session. The court is in session. And calls number 26 CCCR 0088. Case is styled the state of Texas versus Jesus Otaro Rodriguez Caballero. And we have Mr. Rodriguez Caballero in front of us. He speaks Spanish. We have our Spanish interpreter, Ms. Jennifer Araji. Ms. Araji, would you please raise your right hand? Ms. Araji, do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
Ms. Araji, you may put your hand down. How are you doing, Ms. Araji?
Good, Judge. Thank you for asking yourself.
I'm doing fine. Thanks for asking as well. Ms. Araji, ask Mr. Rodriguez Caballero if his full name is Jesus Otero Rodriguez Caballero.
Su nombre es Jesus Arturo Rodriguez
Caballero.
Caballero. Yes, Judge.
Okay. Tell him to raise his right hand. Now, Mr. Rodriguez Caballero, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Vas a resignar todo el verdad de Dios. Pero que dice sí, ¿verdad?
Yes.
Okay, Mr. Rodriguez Caballero, you may put your hand down.
Yes, Padre.
Come on, stop. Yeah, that's good. Now, Mr. Rodriguez Caballero, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Rodriguez Caballero, do you recognize this document?
¿Tú puedes decir esa parte? ¿Verdad?
Yeah.
Yes.
Is this your signature on the line that's titled Defendant?
Y ese es su firma ahí.
Sí.
Yes.
And are these your initials on the line that state you'd like to hire your own attorney?
Pues dice sus iniciales, pues si no con quién saca. Yes, Judge.
Now, Mr. Rodriguez Caballero, before you signed and initialed this document, did Ms. Araji go over this document with you in Spanish?
Pues poner sus iniciales y firmar ese documento, si te explico lo que estabas firmando en español.
Sí.
Yes, Judge.
And did you understand everything that she went over?
Y entendí todo de firmar. Yes, Judge.
Now, is everything in this document true and correct to the best of your knowledge?
Y todo en ese documento es de verdad.
Sí.
Yes, Judge.
Okay? Mr. Rodriguez Caballero, your case is going to be reset to give you time to hire your own attorney. And you'll get your reset from our court coordinator.
También su cita para darle tiempo para agarrar un abogado y no vas a agarrar una cita con un muchacho que está en
Once you get your reset, you'll be free to go and you have a blessed day.
su cita y decir que tienes un día feliz.
And Mr. Raji, thank you for everything
Yes, sir.
and you have a blessed day as well.
Thank you, Judge,
Thank you.
yourself as well. Right.
Jefferson County Code, law number 2 is back in session. Court is in session. And cause number 26 CCCR 0082. Case is styled the state of Texas versus Savannah Michelle Cazales. Would you please come forward? Ms. Gonzalez, your full name is Savannah Michelle Gonzalez? Ms. Gonzalez, would you please raise your right hand? Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Ms. Gonzalez, you may put your hand down. How are you doing? That's good. Ms. Gonzalez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that is titled Defendant?
Yes.
And are these initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. Gonzalez, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Gonzalez, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Okay, Ms. Gonzalez, Ms. Mosby. You hand these bond conditions to Ms. Gonzalez. Okay, now, Ms. Gonzalez, the document that you have before you is titled Standard Bond Conditions in County Code at Law number 2. I'm going to go over these conditions with you. And it states, following return of a criminal information in County Code at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Condition number 4 doesn't apply. Condition number 4 only applies in a DWI case. Your case is not a DWI case. Now, condition number 5 does apply. On the next page, condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that? Now, Ms. Gonzalez, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay. Now, Ms. Gonzalez, you will have are you ready? Okay. Have a seat in that first chair on the wall and wait for your name to be called. Once your name is called, go to the window. Once you finish, you'll be free to go and you have a blessed day.
read your paperwork on that table. Maybe.
Okay, Mr. Mallett, your full name is Ronald Mallett?
Yes, sir.
Mr. Mallett, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, Mr. Mallett, you have gum in your mouth? Okay, Mr. Mallett, there's a trash can. Yeah, you can put it in the trash can. Okay, now, Mr. Mallett, let me do this. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, you may put your hand down. How are you doing, Mr. Mallett? You doing fine? That's good. Well, Mr. Mallett, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Mallett, before you signed and initialed all of these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Mallett, I read your answers. Based on your answers, you meet the eligibility requirement here for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Memphis County Court Law number 2 is back in session. Court is in session and calls number 26 CCCR 0388. Case is style of state of Texas versus Orion G. Madrano. Mr. Madrano, your full name is Orion G. Madrano.
Ryan Gabriel Madrano.
Okay, Mr. Madrano, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing?
Doing good, sir.
That's good. Now, Mr. Madrano, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, Your Honor.
I also have another document that is titled Devils County Affidavit of Indigence. Do you recognize this document?
Yes, Your Honor.
And on page 2 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, Your Honor.
Now, Mr. Madrano, before you sign and initial these documents, did you read the documents?
Yes, Your Honor.
You understand what you read?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, Mr. Madrano, I read your answers. Based on your answers, you meet the eligibility requirements of the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
I was trying to get into a document, but it's locked. It's,
What you mean on the tablet?
yes,
Okay. There you go.
okay.
You know?
What's the court cost in this bill space?
275.
Is there a, I don't see an affidavit in here. Oh, well, city.
Okay.
Then let's put it to. Andrew Jacoby Cooper. The person, that was a dismissal on there.
Yes, sir.
Okay. I'm signing the dismissal.
Why do you send me, bill?
Because I wanted to go into this one, you can send it back. Oh, is it? Unlock it. Okay, next case is cause number 26 CCCR cause number 26 CCCR 0264. Case is style of state of Texas versus Johnny L. Bill. Mr. Bill, would you please come forward? Okay, Mr. Bill, your full name is Johnny L. Bill. Mr. Bill, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing, Mr. Bill?
Fine.
You doing fine? That's good. Now, Mr. Bill, let's see, I have before me several documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? is this your signature on the line that's titled defendant? And Ms. Mosby, could you hand this document to him?
Yes.
Okay, that first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize that document? On the line that is titled defendant, at the bottom of that document, is that your signature?
No.
There are a set of initials on a line that states you would like to waive your right to an attorney and represent yourself. Are those your initials on that document?
No.
Okay, go to the next document. The next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize that document? Now, on that document, there is a signature on the line that is titled Defendant. Is that your signature?
Mhm.
Okay, now, Mr. Bill, before you signed and initialed those documents, did you read the documents?
Yeah, I read it.
You read the documents? Okay, I just need to know if you read them or not. If you did, you can tell me yeah. If you didn't, you can tell me no, you didn't. So, did you read the documents?
No.
Okay. So, let me do this here. Is the folks on Smith time still back there? They not? Okay. Are they next door? Yeah. Just have a seat. We'll call you back up. Okay, just have a seat right there. Okay, yeah. Yeah. Oh. Control. What's this here? Did you you are you already appointed? This is Darcy. Okay. Hmm? Let's see, probably. Yes. Adriana Darcy. Miss Darcy, your full name is Adriana L. Darcy. Miss Darcy, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Miss Darcy, you may put your hand this way.
I'm just coming down and take a look at this. We're still working on this one.
Oh, you are?
Yes, I'm sorry.
Oh, I had the paperwork. Okay. Just have a seat. Okay. Rashad Amarion LeBlanc. Okay, Mr. LeBlanc, your full name is Rashad Amarion LeBlanc. Mr. LeBlanc, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. LeBlanc, you may put your hand down. How are you doing, Mr. LeBlanc? You doing good? That's good. Now, Mr. LeBlanc, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for a court-appointed attorney? I also have another document that is titled that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Sir.
On page 2 of the same document, there are a set of initials, well, actually, there is a signature on the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. LeBlanc, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. LeBlanc, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, the bailiff is going to give you some bond conditions. Okay. And I'm going to go over these bond conditions with you. Document that you have in your hand is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
Okay, and it states following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or orders subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply, and condition number 4 does not apply. However, condition number 5 does apply, and condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. LeBlanc, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay, now, Mr. LeBlanc, you will stand in front of the court coordinator to get your reset. Once you get your reset, you'll be free to go, and you have a blessed day. All right. Nathaniel Campbell. Is that? Oh, well, hold on. Well, I'll get him. Let me get this other person in. Jeremy David Nettenthal. Mr. Nettenthal, your full name is Jeremy David Nettenthal. Okay, Mr. Nettenthal, would you please raise your right hand? Will you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Nettenthal, you may put your hand down. How are you doing, Mr. Nettenthal? I'm doing fine, thanks for asking. Mr. Nettenthal, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney and Waiver of Counsel for Purposes of Entering Guilty Plea. Now, on the judge's explanation, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, Mr. Nettenthal, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Nettenthal, I read your answers. Now, have you talked to the state
Yes,
about
sir.
your case?
Yes, sir.
And state,
The defendant wishes to proceed pro se. At this time, there's no offer on the case, Your Honor.
okay. Now, Mr. Nettenthal, I need to go over. Okay, I need to go over something that is called a Faretta warning and or a Faretta admonishment. And this is from the case of Faretta versus California, 422 US 806. I need to ask you some questions.
Yes, sir.
All right, number one. Have you ever studied law?
Yes, sir.
Okay. Have you ever represented yourself in a criminal action? Do you understand the charges against you?
Yes, sir.
Do you understand the punishment range for this charge?
Yes.
Okay. Do you realize that if you're found guilty, your punishment can be assessed anywhere within that punishment range? Do you realize that if you represent yourself, you're on your own? As a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand that?
Yes, sir.
Do you realize that, well, are you familiar with the Texas rules of evidence and Texas case law?
No, sir.
Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules. For example, do you know how to conduct a voir dire examination? Do you know what are the grounds for excusing a juror for cause? Do you know what is hearsay?
Yes, sir.
Okay. Do you know what are some of the exceptions to hearsay? Do you know what is the proper way to impeach a witness?
Seems like it's-
Okay, I didn't, you say you assume?
Yeah.
Okay. Do you know when character evidence is allowed?
No.
Do you know when and how to make proper objections?
No, sir.
Do you know when and how to move for a directed verdict?
No, sir.
Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for a mistrial? Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court? Do you know how to request and object to a jury instruction? Are you familiar with the Texas Rules of Criminal Procedure? Do you realize that those rules govern the way in which a criminal action is tried in court? Okay, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with court procedures. You're not familiar with the rules of evidence. I would strongly urge you to not try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a trained lawyer?
After speaking with the state, they said that the prosecutor wasn't here, so I was hoping to get a reschedule, and then I will try to associate myself with either Lone Star Legal or someone else of that nature. I didn't want to petition the court for a court reporter because I didn't want to disclose any information to the court that I didn't want to incriminate myself in any way. But I mean,
Did you read the affidavit
yes, sir, but there's
that you have to sign?
the reason that I went to this place.
Oh, first of all, let me do this here. Hold on, Mr. Neanderthal. You have a right to remain silent.
Right.
Anything you say can and will be used against you in a court of law. You have a right to have an attorney. Okay, if you can't afford an attorney will be appointed to represent you before and during any questioning. Do you understand?
Yes, sir.
Okay, so my question to you is it still your desire to represent yourself and give a right to be represented by a trained lawyer?
Like a Fifth Amendment rights on the answer because the prosecutor's not here and.
Okay,
the
the
state's not-
Fifth Amendment rights is, okay, first of all, this is not custodial interrogation. Okay. And so this does not pertain to any facts regarding the defense of your case. This is regarding your right to have an attorney. And so my question to you is, do you still want to represent yourself, or would you like to have a lawyer to represent you? Now I have a document before me that states that you are waiving your right to an attorney and you won't like to represent yourself. So my question to you is that still your opinion?
I explained to the state, sir, and I explained to the bailiff that I wanted to speak to them to find out if we could work it out, that they don't have an offer, but.
They're not making, let me ask you this here. Are you not making an offer because the prosecutor is not here? That's why you're not making an offer?
He didn't have an offer on the case.
No, I'm just saying, so, because if you're not making an offer, because the prosecutor who is on the case is not here, should make an offer, then the case can be reset to give him opportunity to talk to that prosecutor. But if you're not making an offer, period, regardless of the prosecutor being here or not, then there's no offer on the table that can be made. So even if he talked to another prosecutor, it wouldn't make a difference, because if it's the state position that you're not making an offer in the case, it doesn't make a difference who he talked to.
Then it is the state's position that we're not making an offer.
So you're not making an offer at all?
Correct.
Okay. Okay, so the state is not making an offer to you on this case.
I'm gonna ask them. I already should get it.
Okay, now, do you want to apply for a court-appointed attorney? Or, okay.
Yes, sir.
Oh, just have a seat and they're going to give you, oh, you kept it?
Yeah.
Okay,
I'm going to briefcase.
okay. Well, is it filled out?
Yeah.
Yes.
Oh. She's bringing you,
She was trying to find it.
Was.
Apartments. On. Oh.
yeah.
I don't want that. Yeah, I don't want that. No. Bring that down again, because you ripped it off right there. Then you put the bottom number on. That's. Okay. Okay, well, you gotta fill this out anyway. Okay, you can have a seat over there.
Or just.
Oh, that's not fun. Okay. Meet some,
Were they next, were they here?
who-
Someone talk to me? Yeah, I think you said me.
I don't think so. Need some, copies of this. This is a, last form. That's the original. Okay. Okay. Would you please raise your right hand? Do you swear firmly to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, I have before me, another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signatures? Now, Mr. Nenthal, before you sign all the documents that I showed you this morning, did you read the documents? And did you understand what you read?
100%.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mrs. Nenthal, read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you. You will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please stand, have a seat in that first chair. Wait for your name to be called. Once your name is called, go to the window. And then once you finish at the window, you're free to go and you have a blessed day. Okay, you're welcome. Trong Pham, he's in the restroom? Okay, that's fine. We'll come back to them. Mr. Bill, would you please come back up? Okay. Mr. Bill. Okay, now, Mr. Bill, I read, now, called you up earlier, is that correct? Okay, and I asked you if you read the documents that have your signature and initials on it. And you stated that you didn't. Okay, and you have someone here with you, is that correct? Who is that?
My brother.
Your brother. Okay, and your brother is here. Now, sir, what's your name?
Donald Ray Bill.
Donald Ray Bill. Okay, so Mr. Bill, would you come up? Donald Ray Bill, would you come up?
Yes, sir.
Okay, now what I'm going to do, pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all proceedings and trials should be public. However, pursuant to the case of Lilly versus State 365, 321, 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as the interest in security, to ensure that the defendant receives a fair trial and to prevent the disclosure of non-public information. At this time, state, are you requesting that this portion of the hearing be closed to the public to prevent the disclosure of non-public information?
Yes, Your Honor.
Okay. The court finds that the party seeking the closure has advanced an overriding interest that is likely to be prejudiced to Mr. Bill in that it will disclose non-public information. The court finds that this request is no broader than necessary to protect his interests. The court also finds that the court has considered other reasonable alternatives to the closure, and the court makes these findings are adequate at this time. So at this time, this portion of the hearing will be closed to the public.